Hello again, Andrew Cobin, Board Certified Specialist in Estate Planning and Probate Law, and today I want to talk about the roles in a trust agreement. So remember that a trust is just a contract. It's a contract between the grantors, the party who creates the trust, and the trustees, the party that's bound to hold and manage the property inside the trust. And the trust has a third party to it, and that's the beneficiaries. So those are the folks that get to enjoy the benefits of the assets held in trust. So understanding each of these roles is important to understanding what this estate planning business is and ensuring that we're going to create a plan that works. So let's start with the grantors. So the grantors are the party that creates the trust, right? They are going to have powers that are listed inside the trust, and those powers can be very broad or quite restrictive. So in the situations of a revocable trust, typically the grantor has very broad powers. So in other words, the grantor can make amendments to the trust, can direct how the trustee acts, can add or remove the property from the trust, right? And because we have such permissive powers, we have a lot of flexibility, but we don't have any of the protections that might otherwise be afforded, right? So the assets in the trust won't be protected if the grantor gets sued. Similarly, the assets in the trust aren't going to be excluded from the grantor's estate in determining the grantor's estate tax liability. But keep in mind, the purpose of this revocable trust isn't typically to provide those protections, right? The purpose of the revocable trust, as we discussed in other videos, is to ensure a more efficient process if that grantor becomes disabled, to ensure an efficient process for winding up affairs if the grantor dies. Other types of trusts that aren't as permissive are typically the defining characteristic there is that they are irrevocable trusts. In other words, the grantor acting by him or herself doesn't have the authority to change the trust agreement. And we are using those types of trusts for doing things like estate tax planning and asset protection planning. So that's the grantor, the party that establishes the trust and may or may not have powers. The next party is the trustee. Now this is the thankless job, right? The trustee has a lot of responsibilities. So not only do they have to follow the instructions of the trust, they have to ensure that they're meeting their obligations under North Carolina law, and they have to be following the intent of the grantor. So not only interpreting what's the language in the document, but understanding what the intent of the grantors are, all while meeting its obligations under North Carolina law. So a lot of responsibility there, and really this is a growing room for litigation in this area of practice. We see a lot of that where a trustee is either mishandling or alleged to be mishandling assets in the trust. So for the unwise or the unwary, this is not necessarily the best role for that individual. And let me give you an example here. So this one comes up with some regularity. Let's say that the trustee's a child of the grantor, and the grantor is now sick, and the trustee says, well, instead of listing the grantor's house, because the grantor is now in a nursing facility, for example, I'm just going to sell the house to myself. Well, that, without kind of extra guidance or extra steps taken, would be something that could be overturned. That sale could be overturned, right? Because typically the trustee is prohibited from doing acts of self-dealing, and certainly selling the house of the grantor to himself would be an act of self-dealing. The last party to the trust is the beneficiary. So the beneficiary gets all the benefits of the property held in trust. Like the grantor, they can hold that trustee accountable, right? So they are back there sitting and making sure that the trustee is meeting all the obligations under the trust and under law. And one of the tools the beneficiaries can use in ensuring that that trustee is meeting its obligation is the right to an accounting. Right? So typically, unless it's waived in the trust document, that beneficiary is going to have a right to an accounting of all the transactions and also an inventory of all the assets of the trust. So those are the roles in a trust agreement. Keep in mind, typically in most revocable trust agreements, The grantor is also the trustee, is also the beneficiary. So that's how we say we put things into the trust and it doesn't impact the ability to manage affairs, and you hold things or basically manage things the same way you did during your lifetime. But those are the roles. Want to make sure we have a clear understanding of that. Next time we'll come back, we'll discuss the importance of titling assets in trust. Both understanding the roles, understanding the importance of title really is going to make the estate plan work, right? It's going to be designed in a fashion that's going to work to your expectations. So thanks for joining us today, and look forward to seeing you again soon. If you liked what you heard today and found it as fascinating as I do, feel free to share it with a friend by clicking on the link below. Or if you'd like to learn more or speak with one of our qualified estate attorneys, visit us on the web at ncestateplanning.com. Thanks again for joining us, and look forward to seeing you again soon.